Of Justice, first off, if we could just have you weigh in on Solicitor General Menardo Guevara recusing himself from defending the government over Duterte's arrest. Sabi niya, his recusal is not personal, it's
But
institutional. I repeat, not personal, institutional. Can he do that? What do you think?
Well, I think that is wrong because if you hold a public office, a big one, you have your deputy, you have your assistants. If you have a conflict of interest, if you don't want to handle the case for whatever reason, you should just inhibit or recuse personally so that those under you can represent the agency. Because you do not constitute the agency. I mean, you are the head of the agency. And if you say that the agency, your institution is inhibiting, then you deprive the government, especially the president, of legal representation. And you are the statutory counsel. You have only one client, the government. And that is your duty to defend the government in litigation, in cases before the Supreme Court. And if you say that our entire agency is inhibiting, and who will defend now? The president. Of course, the president can ask the other agencies to defend them. But if you have a problem, that is a personal problem of yours. You cannot say that your institution will, whether you are there or not, that is the position of the institution. No. Your next, the one who will replace you will probably change the position. You cannot say it's an institutional position. You are not the institution.
Justice, can I play the devil's advocate? What if lang Secretary Guevara, Sergeant Guevara, feels that not taking part in the deliberations is the best strategy for the government? What if, in his opinion, it would not be good or advantageous for the Republic to take part in the discussions?
Well, that will be his personal opinion because the government has to be defended before the Supreme Court. And you cannot abandon your client. The office of the Solicitor General, tinatawag na yan office because it's composed of, it's an office, a big one. There are many lawyers there, many assistant generals.
Soldiers.
It's part of the executive.
Yes. If you have a personal problem, you do not agree with the position of the president, just inhibit or just resign. You cannot say, oh, we will not all represent the president. That cannot be.
Pero
and besides, yung ground niya, baseless eh. Sinabi niya that the ICC has no jurisdiction.
Yes,
but
sir.
The court already unanimously stated, declared in Pangilinan versus Cayetano that the Philippines remains obligated to cooperate with the ICC because the ICC has jurisdiction over offenses committed while the Philippines was a party to the Rome Statute. That is, and according to the court, that is up to March of 2019.
Pero for Justice, from the very start, untenable na talaga yung position ni Secretary Guevara, di ba? Dahil nung secretary siya ng DOJ, dinepensahan niya yung Tokham. No? Dinepensahan niya yung policy ni Digong. Na ngayon ay nire-reject ng gobyerno. Kaya even before this happened, talaga untenable na yung kanyang posisyon eh.
Yeah, I agree with that because, di ba, sabi ng Philippine government when it was questioning the jurisdiction of ICC, the Philippines said that the courts are functioning. The justice system is functioning in the Philippines because under the Rome Statute, the ICC will come in if the country, the state, is unable or unwilling to investigate and prosecute the crimes that have been allegedly committed. Sino ba yung in the justice system in the Philippines who will start the investigation, prosecution, and the judgment?
The DOJ.
The investigation is conducted by the police, PNP, and the NBI, who will conduct the preliminary investigation. Once the investigation by the police and best completed. That preliminary investigation is conducted by the DOJ. That was under Guevara. Under the office of the president, that means under the control of President Duterte. So the first phase, criminal investigation under the control of President Duterte. The second phase, the preliminary investigation under the control of Guevara and ultimately the president. The third phase is to prepare the information and file it in court. Who does that? The DOJ under Guevara, and the president controls that. The fourth is the prosecution. Who does that? The DOJ under Guevara and under the control of the president. The fifth phase is the decision, the judgment. That is solely the province of the court. So the court is at the last stage. But if there is no criminal information filed with the court cannot do anything. The court cannot decide the case unless an information is filed. And up to today, no criminal information has been filed against Duterte for these thousands of extrajudicial killings. So,
Yes.
Justice,
who during the Duterte administration was responsible for the failure of the investigation and prosecution? It's Guevara. He was the head of the DOJ. And he said
Justice,
that there is no jurisdiction. Precisely there is jurisdiction because he failed to investigate, and that means the government was unable and unwilling. And there's one more. Under the Supreme Court jurisprudence of the Supreme Court, the president during his term in office, while in office, cannot be sued civilly or criminally. So kahit anong gawin mo, a case cannot be filed against the president. That's why the Philippines is really unable to investigate and prosecute because our own jurisprudence says while in office, the president cannot be investigated or prosecuted. So what I am saying is there is jurisdiction by the ICC because the complementarity rule is satisfied.
Justice, ngayon, ang reaction ng Malacanang, tinatanong si Solgen, are you still fit for the job? And there are calls for his resignation. What's your thinking on this?
Well, you see, he was responsible for the failure of the justice system because he headed the DOJ. He should have started the criminal investigation. The NBI is under him, and he should have started the preliminary investigation. The prosecutors are under him. He should file the criminal information. That's under him. And he should prosecute it. That's under him. But he did not do any of those things. That's why the ICC decided to come in. And,
So you think valid yung calls for his resignation?
well, that's for him. But I think it's untenable already to be that he will head the OSG because it's very clear that he has been remiss in his duties.
But the fact, Justice, that 11 other solicitors signed, or was it 10 other solicitors signed the what do you call that, memo, motion, manifestation, that's it. Does that matter? Kahit na ano?
Well, there are several dozens of assistant solicitor generals in the OSG, and of course those assistants will sign because the boss asked them to sign.
So hindi necessarily that like it's not like okay, here's the office of the Solicitor General coming together as a united front saying they are recusing themselves. Hindi siya institutional.
What if
Even
it's
if
a
they all
position?
leave or resign, the office of the OSG will still continue. There are hundreds of them there.
But I think, sir, what Reg is asking is what if there was a consensus within
Within OSG.
that this is the best course for the Philippine government?
Well, that's
Rightly or wrongly?
speculative because there is no consensus, no? I mean, we don't have to answer that because that's not a fact. That did not
Yes, sir.
happen.
Justice, you were in the Supreme Court for a long time and you're familiar with international law. Tanungin ko lang yung opinion nyo, Justice. Pwede bang orderan ng Supreme Court yung gobyerno natin to ask the ICC, pakisoli nga dito si Rodrigo Duterte?
Well, they filed a petition for habeas corpus, no? Under the rules of court, rules mismo ng Supreme Court, you can only ask for habeas corpus if the person you are asking to be produced before the court is within the Philippines. When they filed that petition, nandun na si Duterte abroad. So, tawag namin dyan, moot and academic.
Opo.
Anong tingin nyo, Justice, doon sa sinabi ni Kaufman, yung kanilang abogado, international lawyer, na hihingi siya ng acquittal o anong technical na tawag doon, based on unlawful arrest.
Yeah. And
yun daw yung magiging basihan niya sa atake niya, sa line of attack. Unlawful arrest.
And to add to that, turns out this lawyer is known for contesting procedural matters. So I wonder, Justice, if may nakita po kayong butas in the case.
Is that important? Di ba ang mahalaga sa ICC na sa kanila na? Wala silang pakialam kung paano nahuli.
The highly paid lawyer must put up a strong defense. Sabi niya, I will put up a strong defense. But if he questions the illegality of the seizure, of the arrest of Duterte, he will be running against a tremendous wall. There are many cases decided already by the ICC. This is a long doctrine. Male, captus, bene, detentus. Even if you are wrongfully arrested, even if the arrest was tainted with irregularity or illegality, it does not matter for the ICC. As long as you are presented before the ICC will take jurisdiction over your case and you have to answer the complaint, the charges against you. So, madami na yan. That's a settled doctrine already.
Sir, you're saying, Sir Bale, the ICC does not really care that much about how you were brought before the court. What matters to them
that has been settled even before the ICC was created in the tribunals on the war crimes involving Yugoslavia. Ganyan din. That has been there. It even started during the time of Eichmann when the Israeli agents, security agents, kidnapped him, brought him to Israel.
In Argentina.
And he was put on trial, and his defense was, I was kidnapped. But the Israeli court applied the doctrine of mali captus, which is a doctrine also followed by the U.S. and many countries. And especially in the ICC, that has been repeatedly upheld in many cases already. So if, there's nothing that will prevent the lawyer of Duterte from raising it again. But if he raises it, I expect that the tribunal will just deny it again. No? Will reject that motion.
Justice,
for us non-lawyers, male captus bene detentus literally means wrongly captured, properly detained.
That's correct.
Papaliwanag ko yan kay Panelo pag nakita kami. Male
Alam mo,
captus.
the reason behind that is the ICC is not involved in the illegal arrest. Dinala lang sa kanila yung akusado. So they say, we are not party to that. We're thankful to you for having brought the accused here, and we will try him because he's here now.
But Justice, they were also citing another case,
Yes,
but I'm not sure if this is ICC.
I was
The
going to say
Ibrahim versus Ministry
it's
of...
the State v. Ibrahim, Justice. I wonder if you're familiar with that. So see, this came from Harry Roque, who said they were going to cite the State v. Ibrahim case in order to
That's in South Africa.
argue the point that his arrest was illegal. So apparently, it was a South African case, 1991, wherein the court concluded that it lacked jurisdiction to try a person before it from another state by means of state-sponsored abduction. So we don't know at this point how far they've gotten in terms of petitioning the case, but I wonder if you're familiar with that case as well,
Well,
Justice.
there is an exception to the mali captus rule. If any irregularity or illegality can be attributed to the ICC itself. So it will be in bad faith. But here, I don't see any participation by the ICC in arresting Duterte. The plane was leased by the Philippine government.
I think in the Ibrahim case, South African internal security agents went over to Swaziland to capture a South African and bring him back to South Africa to face the local
He was
court.
tied up,
Yeah.
bound, gagged.
So they went out of their
Yes,
country to bring somebody back in.
Well, that is a different, that's, yung Mali cactus naman is not followed by all countries, but that's followed by many developed countries and especially by the ICC. So a country can deviate. Hindi wala namang unanimity dyan eh. So some countries maybe South Africa does not follow that. But that is South Africa. We're talking of ICC. The South African jurisprudence does not bind ICC. ICC is bound only by its own jurisprudence.
Yes, sir. And Justice, this was a time when South Africa was still
Under
governed by
apartheid. Yeah.
Oh, iba yun.
Apartheid.
But of course, ICC will never follow, will never be bound by the jurisprudence of another country. They make their own jurisprudence. They cannot be bound. A country cannot overrule the ICC.
I think
Justice, because of these developments, meron ngayong mga nagsasabi that the Philippines should rejoin the Rome Statute. What are your views on this?
Well, I'm in favor of rejoining because nakita mo naman what happened during the time of Duterte. Duterte was the author. He was the mastermind of the war on drugs. And that's why the DOJ under Guevara could not investigate him, could not conduct a preliminary investigation against him, could not prosecute him. And no case has been filed in court. And that is why the ICC was created precisely for these purposes, for this particular situation where the government is unable or unwilling to investigate and prosecute because the accused is a person in high authority or probably he's a dictator. That's precisely why we need ICC because it happened to us already during the time of Duterte. Everybody was afraid of him.
Yung isang kaso, Justice, sa South Africa, nung presidente si Jacob Zuma, yung kanyang kaibigan na presidente ng Sudan na wanted ng ICC, ay utos ng ICC ay i-hold ng member state which is South Africa. Hindi niya ginawa, pinatakas niya. Siya yung in-impeach nung kanyang kongreso for doing so. No? Dahil nga, di ba, Justice, obligasyon ng isang member state na sumunod sa ICC dahil may treaty sila. No? May treaty sila. Nung hindi niya ginawa yon ay kinasuhan siya ng sarili niyang kongreso.
Yeah, that's why Putin did not attend the BRICS summit in South Africa because, well, South Africa might change its mind and arrest him, no? So that's why head of state will be reluctant to go out of his country if there's a warrant of arrest against him by the ICC.
Justice, I'll digress a bit kasi si Harry Roque wants to seek asylum in the Netherlands. Kaya hindi na lang daw siya mag-aabogado pa for former President Duterte kasi magpo-focus muna daw siya doon sa asylum. What do you think of that asylum bid considering he's facing criminal charges in the Philippines, particularly for human trafficking?
Well, I think it was a good decision that he will no longer be a counsel because if you go to the internet, you will see Harry Roque saying that do not vote for Duterte because he's a serial killer. And Jan, he was saying it before he joined the Duterte administration. He was telling everybody in that election, do not vote for Duterte. In fact, campaign against him because he is a serial killer. Can you just imagine if he is a lawyer for Duterte in the ICC and the prosecution will present that video and ask him to confirm if that is if he said that. Of course he said that. So he might cause the conviction of his own client because of what he said. So I think it was prudent that he was taken out. Secondly, well, he can apply, that's his privilege, but the victims of the EJ case can oppose, and I think they're planning to oppose his application with the Netherlands.
I think that's why Ronald here calls him an ex-human rights lawyer. but Justice, we know at
Hindi
this...
ka naman dyan.
Di ba maraming times na. But we know from, it's still early days, of course, but we know that the defense is planning to challenge the case on two fronts, jurisdiction as well as potentially admissibility of evidence. What does that mean, and do you see any issues there?
Well, on jurisdiction, that has been ruled already by the ICC, the pre-trial chamber. Duterte can raise it again if he wants, but the ICC has always upheld its jurisdiction if the requirements of complementarity has been satisfied. And I think that's been well discussed already, so I don't think the ICC will change its mind there.
Justice, yung laging dominant sa narrative ng mga pro-Duterte, lagi nila sinasabi, paano yan naging crimes against humanity? 40 plus lang naman yung...
43.
43 lang naman yung pinatay daw. No, yun.
Yung sinight dun sa ano?
Oo.
Sa,
Yung charge sheet.
Anong tingin nyo doon sa ganung klaseng narrative ng mga talking heads ng mga
Ang
pro-Duterte?
requirement naman, there's widespread and systematic attack on a civilian population. But you do not have to present the entire 6,000 people. The trial will take a century to finish if you present all the victims and the families of the victims. So you choose only for the prosecution the strongest cases, and the court will not require you to present all the testimonies of the families of all the victims.
Tama.
Otherwise, they will never finish their work.
okay.
That's not a requirement to include. You choose only the representative acts, and so I think the number of 46 or 40 will be enough.
Justice, you said before that Article 59 of the Rome Statute does not apply in this case. Instead, what really applies is RA 9851. The local law on
Extradition.
what's that? The local law on crimes against humanity.
International Humanitarian
Yes.
Law.
Yeah, that in particular.
Yung
I
Republic
think
Act.
specifically the provision that states that if another international tribunal asks for or makes a request of the Philippine government, then the Philippine government can extradite or surrender the accused to that tribunal. I was wondering, sir, because we do have a process for extradition, but we don't seem to have a legal process for surrender. So how do we implement something like that, for example? Because I understand that surrender is the one that's being quoted as the one used here in this particular case.
Well, we don't have decided cases on surrender to an international organization, but we do have the practice. When we receive a red notice from Interpol, we implement that red notice by arresting, by seizing the subject,
Yes,
and
sir.
turning him over to, let's say, Italy or France, whoever is the requesting party. We do not file an extradition petition before the RTC because it's not an extradition. Extradition is when the requesting party is a state. If the requesting party is not a state, it's not called extradition. No? It's surrender.
It's surrender.
So in this case, it's surrender because the requesting party, ICC, is not a state. And the request was courts through Interpol, so we followed the Interpol practice. Pagdating ng red notice from the Interpol, our agents, the NBI or police will get that person and put him on a plane, and he's sent to the country requesting for his extradition. That is the practice. Now, is that wrong? Do they need a warrant of arrest from a local court? Well, there is no decided case, and the practice is that the NBI and the police do not actually apply for a warrant of arrest in cases of surrenders to requested by the ICC.
Non-state.
I said surrendered by the Interpol, and that was the process followed with respect to Duterte.
So it's already being done.
So
even
Justice,
before
ang
Duterte's case.
description dyan is ES Medjaldea, extrajudicial rendition. May basis ba yon?
Well, when he was executive secretary, the Duterte administration was doing that. When there is a request from Interpol, they don't go to the court anymore. They just seize that person and put him on board a plane.
So
that
even during
this
the
is a
Duterte
case of
government, it
first
was the
impression,
practice.
and if it goes to the Supreme Court, we don't know how it will rule on it. I've been saying it can go either way, but you cannot blame the government because that is the practice even during the
Duterte government.
Aquino administration and so on. That's been going on for the longest time.
Yes, sir. So that's interesting, sir. So we have specific cases where the Duterte administration also surrendered.
Well, I'm sure for the last, during the 6 years, ang dami niyan because these Interpol requests come often.
So actually, when,
Mostly
when
ano yan, Justice, mga terrorist sila, terrorist suspects, ang pagkaalam ko, no? But
All kinds of
yung iba, yung mga
suspects.
for criminal, ano pa?
Halo-halo yan, ang dami.
So when President Marcos says he had no choice but to hand Duterte over because we also rely on Interpol to help us capture our own fugitives,
It's based on practice.
do you buy that, or did he have room to maneuver here?
Well, that's why I'm saying that is the practice. They just followed it. That was the practice ever since. But if you ask me, is that constitutional or legal? Well, I would say it could go either way if it goes to the Supreme Court. But remember, there are two grounds here. The first ground for just to justify the surrender of former President Duterte is because that is the practice under the Interpol system. The other ground is our own law, Republic Act 9851, says the government has a choice whether to prosecute that person charged with a crime against humanity, to prosecute him here, or to turn him over to an international body. So there are two grounds. So I think it's very easy to defend this case in the Supreme Court. That's why I think the DOJ has a very good chance of winning this case in the Supreme Court because the DOJ in fact cited Republic Act 9851, Section 17. We are given, by law itself, tells us you can surrender. You have a
leeway.
choice to prosecute here or to surrender it to an international body that has already investigated or starting to prosecute the accused. No? So we have two grounds. And remember, Republic Act 9851 was enacted before we became a signatory to the Rome Statute. At that time, the president was President Gloria Macapagal Arroyo, and she did not want a situation where a international tribunal will snatch somebody, will order that a Filipino be brought to The Hague. Sabi niya, baka kami yung ipapadala sa The Hague.
Hulihin.
So, he said, we will retain the discretion whether to turn them over to The Hague. That's why nagkaroon ng itong Section 17, an option. We have the option to prosecute him here or to send him to The Hague. So, that is the law before we became a member of the Rome Statute. Then we became a member, then we withdrew. So we're back to that situation where we are not a member. So precisely because of that, we have that option now because we're not a member. That's exactly that's why in the comment of the DOJ, they now use that Section 17 of 9851. We have the option and we exercise that option.
So in a way,
The law
justice
itself says- The law itself says you can surrender.
So in a way, justice, yung pag-alis ni Duterte sa ICC ay bumanda sa kanya.
Yes, it boomerang on him because now that we are not a member, we don't have to follow that duty in the Rome Statute that the country that arrested him must follow, must go to a competent authority to comply with civil liberties, no? To get an authority from a competent authority, that means the local court. We don't have to follow that. We have already a law, and that is what we will follow because that is our law already.
And we are no
That's-
longer a
So
member of
in
the
a way, it
ICC.
boomerang on him because he cannot
Yes.
avail of that anymore. Kasi sa ICC, there's a duty of the arresting state to follow certain procedure. Withdraw niya. So we are not bound by that. We are now bound by Republic Act 9851.
Okay.
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 That's clear.
Yeah,
Hindi na
that's
kailangan
pretty clear to
dumaan
me.
sa
Tawag
local
yat-
court because we are not part of the we're not part of the court anymore, ICC.
Tawag din ng lolo ko, poetic justice di ba?
Pero yung lolo mo.
Lolo mo naman ngayon, no?
Lolo mo.
Habang kumakain siya ng mangga.
Okay, maraming salamat po. That was former Supreme Court Senior Associate Justice Antonio Carpio. Sir, maraming salamat.
Maraming
for sharing.
salamat.
Thank you, sir.
Salamat, Justice Carpio.
Thank you, Justice.